Hi, my name is Lazaro Cardenas, and I head the Loss Mitigation Department at Law Offices of Patel and Soltis in Jersey City, New Jersey. Today, we're speaking with the lead attorney in foreclosure defense for the firm, Mr. Veer Patel.
Hi, how are you?
Good, how are you?
I'm doing well today.
You know, we get a lot of clients coming in at different stages of the foreclosure.
Correct.
And many of the clients want to know, what do I have to do to stay in the house?
Right.
What is your best advice to those clients?
Well, see, foreclosure defense, there's a wide array of options that are available to the client. And it depends really on what stage of the litigation they're in or the process. For instance, you can have someone who's been served a summons and complaint, which is usually the very beginning. Actually, the very beginning really is the notice of intent to foreclose and the lis pendens. But then you have those clients who are facing a sheriff's sale date. Now, those clients are the ones that are really at the end of the process. Litigation is basically complete, and there's a sheriff date, and it's been advertised, and it's going to be sold unless the date's adjourned. So, depending on where you land in that time frame, your options are different.
So, if they're in the beginning of the process, what are some of the options the clients? So, they got the summons and complaint or the notice of intent to foreclosure. What are those documents? What do they mean?
So, the notice of intent to foreclose is required by the Fair Foreclosure Act. They're supposed to receive it 30-some days before the summons and complaint, or the complaint is actually filed. That really outlines some certain rights that they have, and so on and so forth. And there's a lot of materials in there, or content in there, that's required by statute. So you have to be on the lookout for that. So I usually check if that document is accurate itself. Now, once that document's received, and you're talking about the actual complaint, there's a summons that comes with that, and that really is the first document of litigation that basically tells our clients that it's now time to file an answer once they get served, and they have 35 days from service. So after the 35th day, if they haven't filed, the other side can file for default directly with the clerk of the court.
And what is the importance to filing the answer? What happens if they just ignore the summons and complaint and don't file an answer?
So if they ignore the summons and complaint and they don't file an answer, they're defaulted. Now what that means is that that the client or the borrower didn't plead their side of the case in court. So after you're defaulted, there really is no discovery, there is no checks on what was in the complaint, and the bank just moves uncontested across the entire process.
So time-wise, what does that mean to the client?
So time-wise, if you're looking at physical time of the process, it definitely shortens the amount of time that the client has in the home by many months, particularly in New Jersey, because when an answer is filed, it triggers a whole bunch of things, depending on what county you're in. A lot of counties in northern Jersey, they have case management conferences, which I'm a fan of, because it allows both attorneys to connect and go in front of the judge and say if there's, tell the judge if there's any issues. And also go over discovery and if there's any outstanding discovery, etc. In South Jersey, a lot of judges, what they do is they usually just issue a case management order, which schedules everything out without the attorneys even showing up to court.
So filing the answer also gives them additional time to pursue loss mitigation strategies or options where they wouldn't have that time if they don't file the answer, correct?
Well, yeah, so loss mitigation is literally 50%, the other 50% of the case, right? So you have the litigation component, making sure that the mortgage note is accurate, that they are the actual defendants, that it is the actual bank that owns the mortgage. And then you have the loss mitigation, right? Because the client comes in and they want to get out of the mess. I mean, you don't just want to, delay them and keep them in their house with no sort of solution. And the thing is, and that's a huge component. That's more than 50% important, I think, right? Because without it, what are they going to do?